Yes.
Okay. I'm sitting like a cup because I am the fool.
It's funny.
Okay.
Okay, welcome, good morning. This is the Legislative Committee on Judicial Rules. Today's Thursday, July 24th, and we have a quorum and we will get started. So good morning, everybody. The first item on the agenda is the approval of the April 4th minutes, which, thanks to our legislative council, got sent out to you ahead of time. Do people have any changes or comments on the minutes, or I'll take a motion?
I would move that we accept the minutes as distributed.
For a second.
Second.
Right. Discussion?
They look good.
All right. All in favor of accepting the minutes as presented? Please signify.
Aye.
Aye.
Opposed? Abstained? Great. So the first item of business, or the second item of business, is the promulgated rules that we have the Honorable Catherine Kennedy presenting to us on. Sorry.
Person, I think I see Judge.
I see it's Joanne Martell.
I think because she's also listed.
Oh, yes, I'm sorry. Yes, thank you.
Yep.
So
For some reason, I cannot get my video to start. This is Joanne Ertel speaking, but I can continue without it. I guess I will have to.
We'll miss the visuals, but it's good to hear your voice.
And I don't know whether Judge Kennedy was planning to participate or not. She is not.
we don't
Present.
see her.
Excuse me.
We do not see her here, and I don't think any of us have heard from her. So are you happy to go ahead and present?
Sure.
Thank you.
There are, let's see, we have promulgated changes to Rule 3B in order to conform to the statute. The rule previously required all interested persons in an estate to consent to the allowance of the will, but that is not consistent with a statute that does not require all interested persons, as all interested persons could include any kind of beneficiary, charities, non-family members, and the statute only requires the heirs at law and surviving spouse to consent. So Rule 3B3 was just amended in order to conform to the statute. So it's pretty simple, non-controversial amendment.
All right.
Are there any questions?
Joanne, can I ask you a question, which is, I mean, there's a big gulf, there's a huge group of people in between related and what did you said about the initial group of people who can
Beneficiaries.
yeah, beneficiaries, thank you. Right. And thank you, Barbara. And the opening the door to anybody who could claim to be a beneficiary. Is there not,
Right.
Isn't there some sort of additional nuance in that huge gulf between those two groups?
Yes, there is. And initially,
Right.
only the heirs at law and the surviving spouse would have the opportunity, are interested parties in the sense that they're the only ones that could object to the allowance of a will.
Thank you.
Right.
So we don't, if your wills are allowed by the probate court one of two ways, either the heirs at law and the spouse consent or a hearing is scheduled. And typically, the heirs at law and the surviving spouse will consent. And then once the will is allowed, then all the beneficiaries are subsequently notified.
Got it. Okay, thanks. That helped me. Thank you. Thank you, Barbara.
No problem. Other questions? So Eric just reminded me that we did hear about this rule back in April,
Yeah.
which I know feels like
8 years ago.
6 years ago. But we want to make sure we're still understanding it and comfortable with what
Right.
is happening here. So anyone who is on electronically have any questions or concerns? Okay.
I think this rule is scheduled to take effect on January 1.
Okay.
Yes.
Which means, just to add Eric Fitzpatrick, Budget Council, that the posture that it's in right now is that it's been promulgated, so the committee's action, if any, were to be to object. So
Right.
not at the comment phase. it's
That's our
object.
Thank you. Okay.
So the question for the committee right now would be, are there any objections?
Thank you. Thank you. All right. So are there any objections?
No.
Okay, hearing not, we will not take other action. And we will move on to our next item, which is proposed rule, proposed on March 11th. Comments were due back May 12th, the VRPP 54A. Is that right? Am I?
Yes, that rule, the changes proposed to that rule have received a little more attention. Well, let me talk about the genesis of the changes. That in the probate court, in particularly, well, in estates for the most part, but also in guardianships to some extent, decisions are made during the course of the proceeding, which could have a lasting impact if the aggrieved party were not allowed to immediately appeal the decision. Such as, for example, if there's real estate in the estate and the court allowed the executor to sell the real estate, but others objected, and the court overruled their objections, decided to allow them to proceed with the sale of the real estate sold, you can't take that back. So if someone was upset by a decision to sell real estate, they need to have the right to appeal immediately. And those specific instances had not been spelled out. So it was somewhat confusing to parties as to when they could appeal and when they couldn't. There are some who believe that this rule is a good idea. There are others who believe that it will contribute to delay in the proceeding and they should not be spelled out. I think the comments were we had 2 comments, both from trial court judges to whom the appeal would be addressed. They liked the idea, but they had concerns about whether it was premature to allow people to appeal, it would slow down the proceedings. So at this point, we have not requested the Supreme Court to promulgate it, and I think it's going to be considered at the Rules Committee's next meeting in September.
Joanne, it's Allison. Can you see us even if we can't see you?
Yes, I can. Yes, I can see you, and I don't know what the problem is.
I'm glad I'm able to be seen by you because it's good to not see. Question. Couldn't we just create a very tight window for appeal? Couldn't we just create a 30-day window for appeal?
Oh, it is a tight, let's see,
Well, you could even tighten it up because having gone through.
There was not a time, I thought there had been a time frame included in it, but there is not.
I think adding a pretty tight time frame, given everybody wants to settle these things, God forbid they go on for years and years. If you added a time frame, it might make some sense.
I think probably as it stands now, the time frame is probably the same 30-day time frame that there is for other appeals, but certainly that could be shortened. And that's, yeah, I'll certainly bring that
Yeah.
to the
Let's
committee's
spell it out.
attention for discussion in September. That's certainly.
Yes.
Representative.
Well, no, I just wondered why is there, where's the concern come from as far as the delay? Because
Yeah.
we're letting people know that there are these opportunities to appeal and they otherwise don't know about them. I'm just not trying to understand why.
That's true.
Yeah, why is
Or
that a
even
problem?
attorneys don't know, is this a decision I can appeal now? Do I have to wait? I mean, sort of the end of an estate is typically a final decree, and that's the final order. And do people think, some people and attorneys think that they have to wait till that point to appeal a decision. Or they're confused whether a particular decision by the court is something appealable now, or do I have to wait? And this just spells out when you can initiate.
So clearing up confusion in the bar may lead to more appeals and delays, but I guess
It's,
all right.
but people need to know what their rights are. And it's unfortunate that so many people might have appealed and did not. That's the bigger concern. So it does seem like having a really clear explanation for people of when and how they can appeal is really important.
Yeah.
And if there's bigger demand, then that's something the legislature looks at when we look at needs, but not keeping that from people. Right?
Yeah.
I don't know where to look exactly, but yeah. I think you raised a really great point.
Yeah, I mean, I agree with you on that.
And just 30 days, yeah.
30 days is plenty of time for anybody who's actively engaged in a case
And
and paying attention.
so
At this point, as I understand it, there is not necessarily a lot of consistency. That some of the areas we've outlined could be, certain issues could be appealed to the civil division, and the civil division might take the appeal. They might kick the appeal back to the probate court saying it's premature. So the hope was that it would create consistency and clarity.
And is this the only area where there's been confusion and lack of clarity? Does it feel like it's clear elsewhere, or do we need to make sure people know what their rights are to appeal in the state?
I guess I'm not sure I understand your question.
Is it really this very targeted part of the appeal process for an estate that is in question? Or might there be other areas of confusion that just have not been addressed yet? I don't know, maybe you don't know the answer to that, but I think the point that you just raised is concerning to me about people not knowing what their what their rights are and wanting to make sure.
I think these are mostly lawyers that are dealing with this kind of thing, and I think they probably are pretty clear.
Not a
I
lot
think
of,
giving them a 30-day window is plenty of time.
not a lot of self.
No, I wouldn't think so, not in this situation.
Okay.
No.
Are
Right.
you suggesting, Allison, that there should be a shorter time frame than 30 days?
Not unless you are.
Yeah.
No. I mean,
Okay.
no. I think
Okay.
let's be consistent. I think consistency is useful.
Okay, so now what's the next step? Is it,
So these rules haven't been promulgated yet, which means that they're in the stage where the committee makes comments, which I think you just did.
Yes.
So you made your comments. I think the Judge Rutel has heard those, and I think if I heard the judge correctly, they're still pondering whether they're going to promulgate it this fall.
and
And they
it'll
can
be on the
take comments
agenda?
that you just made into consideration as they're thinking about it.
Great. Any other comments or considerations we want to share? All right, so then I think we're ready to move on to.
I have
Thank
one
you.
question before you
Okay.
move on. Just in terms of your procedure, do you typically review rules before or after promulgation, or both?
That is a really good question. I think our goal has been to do both.
Oh,
Yeah,
Both, okay.
and I would shift
Sometimes it
around our
hasn't.
time to
Right.
enable that.
because sometimes we've missed before and we're trying to avoid that.
Well, this rule, I'm sure will come back before you again.
Yeah, it will
Sounds
be
good.
given the stage that it's in at the moment.
We will look forward to that, and we thank you very much for
Okay.
presenting today.
Thank you all. Sorry I could not appear visually.
Well, we really want you to appear in person so that we see you again and that you can have some of Terry's delicious cookies.
Wonderful.
Thank you all.
So great. So the next item on our agenda is a proposed rule, and I am thrilled to say that we do have our former Justice, the Honorable John Dooley, here with us, who is able to appear on Zoom in, and we can see him, and hopefully you can see us. So Justice Dooley, shall I turn it over to you to talk about the rules for electronic filing 9?
Sure. Thank you. And good morning, everyone. This is a true housekeeping amendment, so only 10 minutes was assigned for purposes of considering it, and I don't know that we need that. But just a little background. The rules of electronic filing were created by the Supreme Court when the judiciary went to electronic case file and electronic filing in 2020. They were implemented over a period of time. So the 2020 rules are actually 2020 and thereafter. The biggest addition was after the trial courts were done, the Supreme Court was then done, and that required a whole new round of rulemaking to do. But now we've pretty much resolved all of the questions. And those of you who have been in the legislature for a while may remember that there were some controversies and difficulties when electronic filing was originally introduced. Over time, I think they've been largely resolved. So the work in this committee is much less than it used to be. I'm sorry, did I interrupt you?
No, I interrupted you, John. I apologize. I simply said that your characterization of it was generous.
There is one more addendum that is in planning and actually should occur soon, which is to extend these rules to lawyer disciplinary proceedings. Obviously, lawyer discipline is a small number of cases in relation to the other reason to do it, but we have been working on that for a period of time. And there were some questions that needed to be addressed about the operations in lawyer discipline that delayed us doing the electronic filing rules related to it. But those are now, I think, pretty well resolved, or at least at the Supreme Court for purposes of resolving. And so you will come to see those rules, I think, pretty soon. So this one is simply that when the rules were written in 2020, we talked about how court-generated documents were to be created and filed, but we didn't. So we said that that's what judges and court staff would do. But it turns out that there are documents that come to them for signing that aren't really court generated. So this housekeeping amendment is simply to eliminate the terms court generated for it. You can see what we're now dealing with in electronic filing in relation to what it used to be for these kind of housekeeping things are now being covered. Let me also say is there is now a very, very full complement of procedural I won't call them rules because they don't have that same status, but instructions on the website of the judiciary to answer all of the questions that have arisen generally that supplement these rules. I'd be happy to take any questions.
So I just want to make sure that I understand. So this gives the court a way to deal with signing documents that don't originate with the court, that are coming from other sources to the court to sign.
Yeah, and the reporter's note indicates a very common one, which is that the court will say, when the decision comes out, please, counsel, prepare an order for me to sign. The order will go to the court to sign, and the court presumably will sign it or indicate there's a problem with it, but mostly sign it, obviously. And it's not court generated. So the way that the language was cast earlier is too narrow, and we're just broadening it to cover all the instances where the court is signing something and getting it filed.
Yeah. Questions or comments?
Thrilled, it's ever improving.
Wonderful.
Ever, yeah.
Something to cross off the list.
I feel my first crosswords in this committee were spoken about this work. And I'm so excited that it's
I missed all of that.
my only, oh, what? Yes, I think that's true.
So we're
And the cookie's
not
starting to
taking
be sweet.
an action other than,
The comments are.
okay, wonderful. Thank you. So thank you. That's very helpful. And it's really great to have you here. So thank you.
Thank you, and it's a pleasure to be. I think probably I have appeared before this committee more than virtually anywhere else, because I was originally a reporter for rules before I became a justice and before I became Secretary of Administration. So I was regularly appearing for all of the rules at that time, and I've continued to be so over the years. So
it gives us all pleasure. So it's great to
It
see you.
does. Yeah. Wonderful.
Thank you very much. Your continued engagement on all this is really wonderful.
Yes, and we look forward to seeing you at our next meeting for some other issue, I'm sure. So, thank you.
thank you.
So we are doing great. We're making up our time in flight here. So the next issue before us is the FRE 502 rule, which we have Judge Corbett presenting, and I'm sorry?
It looks like he's in the waiting room.
Oh, he's in the waiting room. Thank you. Good.
Everyone-
There's a technical glitch there that signed me out of Zoom.
Okay. So we will get him in the room.
Barbara, while we're waiting. Workforce meeting.
Oh, perfect so far,
Yeah, well, maybe we'll get you out.
Yeah. We're stop.
Yeah,
Made up for all our,
maybe we'll get you out another time.
yeah, I apologize.
That's okay. Good to see you. Don't forget to the Otter Creek Bakery when you're in Middlebury.
So, well, I'm going to the Hannaford
Career Center.
Career Center.
Yeah,
You know where that is?
yeah, you
Where?
stay on
Is it on
Route
Route
7.
seven?
Yeah, you go through the traffic circle and then,
Down, so
Top
it's
down,
south,
yeah.
towards Rutland.
yes.
I can get there.
The one in Middlebury?
But,
The one in Middlebury? you're going to?
yes, that we have a CTE meeting there.
I commuted to Middlebury for 3 years. When I first moved to Vermont from Burlington,
Wow.
from the New North End. Yeah, when Bill Lippert hired me and was my boss.
Oh my God, of course, then you, right.
Yeah.
I forgot that Bill was your
I know.
boss.
And he's like, you won't do this commute for more than 2 months. I was like, yeah, I will. So.
I love, and then of course you, well, and then Lund, you did all.
I didn't, that
When
was
he was on the
after
board
the
at Lund.
month, but. and-
Wasn't he on the board at Lund?
No, he was interim.
Ah.
Yeah, yeah. So anyway, I love Vermont for, all connected, but my office was across the street from the Otter Creek Bakery, so
Very lucky.
yes, very nice. All right, so while
Just
we're,
in the meantime, just to add real quick, just so you guys may remember this, but rule was 4 and 6. 4 is the one that the witness in the waiting room, the evidentiary rule. 6, which refers to the family rules, were both supported by this committee.
okay, so there are two items, yeah, not one,
We have
thank you.
support, yeah.
Yes.
And should we? Yes, we should, what, we need to wait for, obviously, Rich Corbett. I just wondered if we should try to.
Why don't we try and, is there, yeah.
Could we go to the next
bounce around?
issue, but I don't know if we have,
I think they're probably all on Zoom, so I don't see anybody else here, so probably we're.
right?
I think that-
And I know we have, and I know you frequently are presenting,
She steps in.
right? In fact, I think at our last meeting, you did.
Yeah, that's, she did.
Is there anything you're doing,
Stepped in a
Solar?
lot.
Is there anything that
Right.
is in solar for us?
Right,
I'm gonna cover all of civil.
Can we jump to civil?
that's a great idea.
Let's jump to civil since.
See,
I
it's
know
nice to
that-
have.
I know that Corbin is in the middle of good.
Oh, okay.
Okay, thank you,
So,
thank
I know
you.
that the time-
Right, okay.
Yeah. no.
So we will, Judge Corbett's in now, so thank you. We're happy to have you with us. I don't know, can you hear us?
Yeah, sure can. Thank
And-
you.
And we can see you and hear you, so wonderful.
Oh, there.
Sorry for the technical difficulties.
Quite all right.
And welcome. So I understand you will be speaking to both BRE 502 and BRE 106.
Yes.
I'll let you-
So,
Way.
sure. So Rule 502 was an amendment that was requested by the Vermont Bar Association. The idea is that they have a lawyer referral service that someone can call and say, I'd like an attorney, and can you recommend someone for me, please? And there was a concern from the VBA and from the people staffing that service that they might be called into court to testify about what someone told them when they called that referral line. Like if a defendant called the referral line and said, I've done something bad and I need an attorney, they were concerned that the people answering the telephone might be called as witnesses in court to say that the defendant said, I did something bad. And so the VBA requested that the lawyer-client privilege be extended to cover those communications and to make sure that that wouldn't happen and that those conversations would remain not used in court. The request was made by the Vermont Bar Association prior to the pandemic, and progress on the amendment was delayed during the disruption caused by the pandemic. And so we've now completed the process of fulfilling the request from the VBA for that privilege. There, other than Bob Palini was very active in proposing the amendment and provided the committee with research from other states where very similar measures have been undertaken without controversy. And in the process, the only public comment that we had was from VBA in support of the proposed amendment. We had no other comments publicly or in response to the proposed rule. And so the committee has unanimously recommended it, and that rule has been promulgated by the Vermont Supreme Court.
Great. And I'm curious, did this rule get generated because they were trying to prevent this from happening, or has the situation actually occurred in Vermont where people were?
We have no reported anecdotes of this ever happening. The rule was meant to be to prevent it from ever happening.
Proactive.
That's great. I just was curious. Okay. Other questions or comments for Judge Corbett? Yes, Senator Brock.
Just a question. I gather that this was brought up during the pandemic, which was what, 2022. It's now 2025. Why did this take so long?
It was originally proposed, I think, in 2019. there were no meetings of the committee between 2020 and 2023 on account of the pandemic. It was one of the first, the first project that we undertook following the pandemic was a revision to all of the evidence rules, removing gendered language and other aspects from the rules. This was the second project that we've undertaken. I forget exactly when it was submitted to the Vermont Supreme Court as a proposed rule, but it was actually promulgated either earlier this year or late last year. So we're just now meeting about it in this committee, but it was promulgated at least some months ago.
Well, I can understand that this is a situation that has not resulted in any issue or harm, but it could have. And I'm just concerned of why something would take 6 years to be dealt with and presented to us. That seems like a very, very long time, doesn't it?
I agree.
I mean, I know there probably were, I've only been on this committee for a short time, but I know that there was a backlog and probably things were prioritized. I know, yeah, I mean, you raise a good point, and I don't know what else is on the back burner that we're seeing now, but we know the judiciary's resources have been pretty thin, dealing with a lot of changes, right?
Well, I, for one, I'm just very concerned about what seems to be an excessive amount of time to deal with something that seems fairly straightforward. And it simply raises the question in my mind of what else is out there on the back burner that's been simmering for years that none of us have heard about. And is there a way for us to at least get an understanding of, is there something out there that would be a real concern to us?
I think Emily and Terry would probably have flagged those for us, and maybe they could update us at some point, either at this meeting or next, about what has been in the works in terms of rulemaking that is not sort of on track. But I hear you, Randy. I think it's a concern, but I also know that the rules are worked on by a lot of people who are very busy. I mean, this is extraordinarily long. Ongoing rule improvements like the electronic filing one has been ongoing, and there's been work on it constantly since 2020. But with this, I mean, yeah, it's a lot of retired people and people who are working pretty hard to make extra time to do the rule work. So I don't know, but maybe Emily and Terry could update us on other things that are maybe in the works that have taken a little longer than expected. Maybe we could have an update on that, and there may not be any. This may be the longest one.
And I don't know.
I don't know. You're the ones who know. We don't.
Are you asking for an update right now, or?
No, I think that would be unfair.
Yeah.
But I think
Could we
an
hear
update-
something at the next meeting that just brings us up to date on what's hanging?
Sure.
Absolutely.
I can report to you, Senator Brock, that with respect to the Evidence Rules Committee, that was the last remaining item that had been discussed prior to the pandemic. All of the business we're currently discussing are new matters.
Thank you.
Thank you. And we will put that on the agenda for next time and see if we can try to look at where there might be some long delays that.
Yeah, right.
Yes,
all right.
Great. So other concerns, questions, comments on this rule before we get to the next one?
Nope.
All right, so let's move on to the next one, Rule 106.
So Rule 106 is the rule of completeness. And what it is a rule of fairness. The idea is that if a party is introducing a statement that someone made, usually the other party, and the party is seeking to introduce the statement in a misleading way, the rule allows for the misleading impression to be corrected right away rather than having to wait until the other side presents its adversarial case. So, for example, if a defendant in a criminal case has made a statement that they owned the murder weapon, but that they sold it many months before the alleged murder happened, it would be misleading for the prosecution to introduce only the part of the statement that the defendant owned the weapon without also introducing the part that they sold it many months before the murder happened. So the rule of completeness is meant to address that situation. There have not been any problems with administering the rule in Vermont, but in some federal courts, there had been a problem emerging that the hearsay objections were being made and were successfully preventing the misleading impression from being corrected. And so the Federal Rules Committee did not have a favorable view of that development, and so amended the federal rule of completeness to make very clear that the rule is a rule of fairness and a hearsay objection should not be used to prevent the misleading impression from being corrected. Again, there was no reports that this had been a problem in Vermont, but we were concerned that if we did not accordingly amend our Vermont rule, it might give the impression that we were rejecting the new federal rule and that we agreed with the courts that the hearsay objection could be made. And so the Vermont amendment was made to be consistent with the new federal rule and to make clear that we agree that the hearsay objection should not be successful in preventing the misleading impression from being corrected. We did not receive any public comment on the rule during our process, and after it was proposed by the Vermont Supreme Court, we received no public comment in response to that proposal.
Great, thank you. Representative Malone.
So thank you, Judge. So was there consideration of whether there should be any qualification for admitting the hearsay? I know, for instance, Rule 804A has language that along the lines of that the time, content, and circumstances of the statement provide substantial indicia of trustworthiness. Was there any consideration of having that additional language in there?
No, only because the way the rule of completeness works is it's a rule that applies when the other party is presenting evidence. So if in a criminal case, for example, the prosecution is introducing a statement, and it usually would be a statement of the defendant. And so the rule of completeness allows the defendant to require the prosecution to introduce the complete statement of the defendant that's being offered rather than a misleading portion of that statement. If there were other so the types of considerations that might come up in Rule 804A, for example, would not necessarily apply. The point is that the whole statement be admitted in a non-misleading way.
I see. Okay, I understand. Thanks.
So, Barbara,
Not at all.
Okay, I'm sorry, thank you.
So this is a question for you, Jean, but also for Terry and Emily. What are we doing, given that we may not agree with many of the new rules coming from the feds, and we may actively object? Have we created a committee that is sort of monitoring the new federal rules that are coming at us? Or do we already have that in place? I mean, just given what may happen and what is probably already happening.
May I ask, you mean like federal rules of evidence or federal?
Any
rules of
federal rule that
procedure?
is a judicial that has anything to do with this administration's new ideas of new rules? And how do we screen those and decide whether we're going to comply or not?
My understanding of the federal rule committees, for example, are very similar to the Vermont rule committees.
Okay.
They're made up of practitioners, they're made up of persons expert in that area of law. It's not typically something, and Judge Corbett, you can correct me if I'm wrong, but my understanding is the federal rules bodies are not, for example, directly, I don't think.
Are not typically very political?
They're not partisan.
They're not partisan,
That's not my-
or at least they haven't been hitherto.
That's my understanding.
Okay, so that's good.
But from Emily Wetherell, the Deputy Clerk of the Supreme Court, I mean, I think we would continue to operate as we always have, and that is that we have our own procedural rules here in Vermont. Many of those rules are, or at least were initially modeled on the federal rules, or in areas where we didn't have, because they are particular to state issues and not federal issues, they were modeled on the main rules. But what the rules committees usually do is see what changes have happened to the federal rules and then consider whether an amendment to the Vermont rules would be appropriate or not. And there have been many instances where committees have looked at what the how the federal rules have been amended and said, for whatever reason, that's not an appropriate amendment to make for Vermont procedure, and you know, decided not to do that change. That's exactly what Judge Corbett's explaining here. You can explain further, but I think the reason this came about is that they regularly look at how the federal rules of evidence have been amended and then consider whether to make that change.
Great, so nothing to be concerned about yet.
I was gonna say, our rules committees are not bound by the federal rules committees, oftentimes because they involve very similar issues that might arise in a trial court setting. It's helpful to, you know, get the input and decide and determine whether it will be applicable or helpful or reasonable in Vermont.
But
But,
federal rules trump Vermont rules, right?
well, no, not in the state
Not always.
courts. Our state courts
Okay,
are
good.
governed by our state rules of evidence. The federal court in Vermont, if you bound by the federal.
Thank you. That's helpful.
That's helpful.
Great. So Senator,
I can very briefly describe for you what that looks like in the Rules Committee, which is that I will frequently bring to the committee, I will say, okay, here is something that the Federal Rules of Evidence Committee has done. And then invite our committee to express, is this a problem that you've seen in Vermont? Do you think this represents a problem that we need to address in Vermont? Do you agree with the federal rules amendment, and should we do something? And so that conversation very frequently results in a conclusion, either there's no need for action because it doesn't identify a problem in Vermont, or there's no need for action because we don't agree with it, or that's a good idea and we should do it too.
Great, thank you, Dean, that gives me some peace of mind. Great.
thank you. So Senator Hashim.
Thank you. I'm curious about situations in which a hearsay statement is introduced, under Rule 106. Can that statement only be used for providing context and avoiding misleading the fact finder, or can it also be used as evidence, or do they just go hand in hand, and are they inseparable?
It goes hand in hand. It's not a rule that comes up often, because it only comes up if an attorney is trying to introduce some out-of-court statement in a misleading way. And so it's not really a substantive rule of evidence. It's more a rule of fairness for the trial judge to correct a misimpression before it sets in and takes root with the jurors.
Okay, thank you.
So any other questions or comments? Thank you very much, Judge Corbett. We very much appreciate you being here and presenting and the work that you and your committee are doing.
Thank you very much.
Great, thank you. So next on our agenda is we're going to hear from the Honorable McDonald. Katie? Is it Katie?
Hey, Judge Davenport is going
Judge Davenport.
It really is maybe.
You know what? I keep not reading down to the second line, so.
Well, it depends on who's available in the middle of the summer to come and talk to you. She has a full juvenile docket, but she is the chair of the Family Rules Committee. Just for the record, I'm Judge Amy Davenport. I am the reporter I'm a retired judge and the reporter for the Family Rules Committee. And I'm here to talk to you about 3 rules. One has been promulgated and was effective January 1. The other 2 are pending promulgation.
Great. And I don't know if you'll end up knowing this, but if you have a backlog in your committee on rules, that would be helpful also to hear.
Ooh, we have a lot on our plate.
Okay, all right.
I didn't bring
Maybe for the next
July's
meeting.
agenda, but I could send you July's agenda and you could take a look at it.
I had a specific question on that. I mean, do you anticipate any rule changes from the standby guardianship law that we put in place? And is that one that could be expedited if it's needed, you know, because of the situation?
If it's needed, nobody has brought it to our attention, but I will make a note right now to take a look at it. A lot of, I just would say by broader explanation. Well, first of all, let me introduce my granddaughter.
Yes.
Marcella Kinzel. Marcella is from, going into 9th grade. She lives in DC and her father was once a page here.
Yes.
So on the standby guardian issue, I will take a look at it and thank you for bringing it to our attention. A lot of the legislation that gets passed now, and we're going to talk about a couple of instances where this is true this morning, are instances where you as a legislature have incorporated a lot of procedure into the statutes themselves. And so the question then becomes, do we need rules to simply parrot what's also in the legislation? And sometimes it makes sense to do that because practitioners use the rules a lot and it helps to find it and just cross-reference the statute. But sometimes it also means that those pieces of legislation, unless somebody brings them to the Rules Committee attention that something needs clarifying or procedure needs to be created, they don't get the immediate attention that legislation that doesn't talk about procedure at all, just talks about the substance, but doesn't talk about procedure, that's going to get pretty immediate attention because there needs to be some procedure. But in the family, particularly in the family area, you all tend to put a lot of procedure into the legislation.
Which is helpful or not helpful?
No, it's fine. It's helpful. And I think it's helpful, as a former legislator, I can see where it's helpful to work through what the process is going to be. So it's not that it's not helpful. It's just that then the question becomes, do we really need a rule? And we're going to come to a couple of instances, starting with the very first one, which is related to some new rules related to your legislation from 2020 on vulnerable non-citizen children. Under the INA, non-citizen youth, or actually their custodians, can apply for something called special immigration juvenile findings, asking a court with jurisdiction over the custody of the child to make special findings that would then allow them to be considered for citizenship by the INA. The rules that were promulgated specifically impact divorce and parentage cases under Rule 4, 4.1, and 4.3, which are all the rules for divorce and parentage cases. We initially, again, this was, if you look at the 2020 legislation, it has a lot of procedure in it. Initially, it did not appear to anyone that special rules were needed. But we were contacted by the Vermont Immigrant Assistance at the law school at Law and Graduate Schools Center for Justice Reform about they wrote us a memo about two issues that they felt the rules needed to address. One was when a petition was filed, usually along with a divorce complaint or a parentage complaint, and when the petition was filed requesting special findings, what would generally happen with a new divorce or a new parentage, it would be scheduled first for a case manager conference. And then after the case manager conference, then be heard, any motions would be heard by the judge. They pointed out that delay, that causes delay. And then in a lot of cases, those special findings, there needs to be, they need to be made quickly. So one part of the rule addresses making an exception in terms of the scheduling of those conferences. If a petition has been filed, scheduling it immediately in front of the judge rather than and bypassing, at least for the moment, that case manager conference. You could come back to the case manager conference, but getting the special findings decided first is important. The other piece, which I don't think anybody had picked up on, the legislation appropriately, I think, allows for service to be waived. And the rules for divorce and parentage cases do not provide for waiver of service. Waiver of service is generally it's very rarely allowed to totally waive service on the other party. There's service by publication, but a total waiver of service is unusual. There are a couple of instances where it's permitted in the civil rules, and I don't remember them off the top of my head, but with respect to divorce and parentage cases, waiver of service was not an option under the rules. And so this rule amends that to allow only in cases where a petition for special findings is filed, allows service to be waived. It does require, and this is the only, the statute simply says all methods of service, including waiver of service, and really doesn't make any mention of a procedure related to asking for waiver of service. We require in the rule that in order to get service waived, the motion has to be accompanied by an affidavit and setting forth the names, obviously, some obvious things like the names and the location of each parent. But if the name or location of a parent is unknown, and I'm looking at page 3 of the rule, if the name or location of the parent is unknown, a detailed description of efforts that have been made to identify the parent or determine the parent's location, and the reasons why service cannot with due diligence be made by any other prescribed method, just so that it doesn't become the reflexive, oh, we're filing for special findings, therefore we're going to ask for waiver of service. You really have to think it through. So those, as I said, these rules have became effective January 1, 26. I'm happy to answer any questions.
Great, no, that's helpful. Questions?
Okay. Okay, so there are two rules that are currently have gone out for comment. And the comment period has been completed. The committee met on July 11th and voted to refer these two rules to the Supreme Court for promulgation. The first is a new rule in delinquency proceedings, which allows for the juvenile court, a judge basically, to order temporary conditions of release in delinquency cases. pending a merits case. Prior to this, well, going back to a lot of rules for adult court in the criminal rules apply to delinquency proceedings. But the rule in adult proceedings in the criminal rules that allows for conditions of release, temporary conditions of release to be put in place prior to arraignment does not apply to juvenile proceedings. And in fact, we decided that it doesn't really fit juvenile proceedings, and it was better to create our own rule specific to juvenile proceedings. But I just, by way of preliminary, in criminal cases, temporary conditions of release ordered by a judge have been ongoing for decades, whatever. So the and one of the reasons to have them is that you may, by allowing the judge or the court to impose temporary conditions of release, you may avoid placing a juvenile in a correctional facility until their first hearing. So if you want them to stay away from somebody who they may have harmed, you could put a condition of release that they not have any contact with that person, or that they live with a particular person who would have supervision over them. It's for a relatively short time. If temporary conditions of release are imposed, the court has to set the preliminary hearing. That's the arraignment, basically, but in the juvenile context, the preliminary hearing has to set that within 72 hours. So it's a very short time. And then at the preliminary hearing, the court can hear from both sides, can look at the conditions, might add conditions, might change conditions, but can put the conditions of release. The conditions of release are pending, basically pending adjudication of the case. It seemed to make sense. It was supported. We had no comments from anyone other than someone who suggested that it should apply in youthful offender cases as well. And when we looked at the rules, we realized it will apply to youthful offender cases. So there was no reason to make a change for that. So the committee has voted, as I said, the committee has voted to request that that rule be promulgated.
Right.
Happy to answer any questions.
Are there any questions or?
So this is just kind of, it's expanding or providing a little further clarification on the subdivision F 5225, 335225 subdivision F, which I see does provide that the court may order the child to abide by conditions of release pending a merits or disposition hearing. What this is talking about, I'm just trying to make sure I understand this, is they're temporary.
Right. And the statute is, I should have mentioned the statute. The statute is not specific about at what point can those temporary conditions be imposed. And so in the past, because the adult rule didn't apply, it has been presumed that they could not be imposed until that preliminary hearing, which can sometimes be 6 weeks away, sometimes it's a long time. This allows in a specific case, it would be a serious case probably, but allows it to be imposed right away with a hearing in 72 hours.
So were those temporary conditions of release, has that been the practice anyway? And that's how it was?
The practice has been to wait till the preliminary hearing.
Okay, all right.
That's been the practice. And we, it was pointed out to us that there are instances, not a lot, but there are instances when it would be very useful to have those conditions of release imposed temporarily. And that then would trigger a faster preliminary hearing.
And in lieu of having somebody have to be removed while they're waiting.
Right. In lieu of placing a youth, for example, in DCF custody while you wait for their preliminary hearing. I would say the Defender General's office was in strong support of this. The AG's office is in strong support of this. The prosecutors are in strong support of this. It was a very non-controversial rule, as it turned out. Any other questions?
Yeah, it's just kind of, because this particular rules seems, I mean, that it's I wouldn't call it a substantial clarification or change to what we have in the legislation. And is it, I mean, I assume that sometimes we get close to the line where the committees of jurisdiction in the legislature should look closely at something. I don't know that this is one, but it seems pretty close. But if I'm hearing that everybody was fine with it, you know, all the relevant parties, then is that something we should worry about?
I'm trying to remember in the criminal context whether temporary conditions of release are simply by rule and not even by statute or not. I don't remember. The statute was not specific as to when they could be imposed. So all this does is create that. But and obviously the legislature could meet next year and say, gee, we really don't want, not next week, right? But could meet in 2026 and say, you know, we were happy with how things were before and we're gonna, you know, and then that would overrule the rule change.
Well, it might be interesting to see how often this ends up being used and what the feedback is.
Well, I think also just the fact that the defenders and prosecution are in agreement with this, that why don't they disagree?
I wonder about like his DC, what the DC.
So many other.
That's true. That's true.
Yeah.
Right.
I don't know whether they can flag how many times this actually gets used, but
I would think there would be a code for that.
there would be, I would think so.
Check for data.
Okay.
And I know with the adult conditions of release, a concern has been the relevance of the conditions to keeping the public safe or avoiding holding somebody. And I'm assuming that these conditions would also not be, you know, must meet with a math tutor, you know, or something.
Yeah, I can't imagine the fact that you're probably calling a judge in the middle of the night.
Right.
That the judge is going to be interested in the math tutor.
Right. Right.
But I think you basically have a prosecutor asking put conditions of release so that they don't have to place the kid in DCF custody. That's probably what would, that's what the situation would be. Yeah.
That's one of the questions. And so if the conditions of release does that put in there temporarily, does that change any incentives for how quickly the preliminary hearing is going to be set? I mean,
yeah, 72 hours. It has to be set in 72 hours.
Yeah.
It's a 72-hour rule.
I didn't read that very
Which is
closely.
great. It seems.
Okay, all right.
It bumps it.
Right in the rule.
Yeah, right. It bumps that preliminary hearing right up, right?
Okay.
So ones that don't have them will not.
Right, well, this is,
Yeah,
I
yeah,
think this is
great,
good.
thank you.
Yeah, no, I think it's good.
Good, good. So the final set of rules that have been out for comment period is completed. We received no comments on July 11th at the meeting. On July 11th, the committee voted to recommend that the Supreme Court promulgate them. And so I anticipate if the Supreme Court does promulgate them, they won't go into effect until January 1. This creates a whole new rule. It has taken us quite a long time. I think we've been working on this rule for probably well over a year.
It's not that long right now, actually, considering what we've been.
Just because it was a brand new, we're starting from scratch. I think initially when people looked at the ERPO legislation, they thought, oh, the relief from abuse rule will just apply the relief from abuse rule. But actually, relief from abuse rule is not applicable to this type of proceeding, especially after the 2023 legislation that amended it and allowed a household member to file for an ERPO, an extreme risk protection order, for a temporary ex parte order. It's a proceeding that's quite unusual in my experience, in that it's kind of a hybrid between a family proceeding and a criminal proceeding. The state's attorneys basically have control of the bringing these cases. For the most part, most of the cases that have been filed so far for ERPOs have been filed by state's attorneys. There are, I don't know actually how often a household member has asked for it, for at least for the temporary one. But once they get the temporary ex parte order, the case immediately goes to the prosecutor, and the prosecutor takes over. So one of the questions that we had to sort of think through was, where does that leave the family or household member? And it could be a case where a family member is asking for a weapon to be taken away because they're concerned about a suicide from maybe their adult son or their adult daughter, because they're concerned about a suicide. Or it could be a situation where there's fear that it's going to be used for extreme harm to another person. What we decided basically in constructing this rule, and again, this is a statute that has a lot of procedure in it. And the statute is specific that the rules that govern extreme risk protection orders are family rules, not criminal rules. I have to say that there were people on my committee who looked at the legislation and said, oh, we should send this to the Criminal Rules Committee. This is really a criminal matter. And it's like, no, the statute is very specific that it's family rules. I don't know. So just a couple of the issues really dealt with where does the family member who gets the temporary extreme risk protection order, where is their standing? And basically we made them what we would call interested parties, so that they will get notice of hearings, they will get notice of orders that are issued. But they don't have party status because the state's attorney has taken over the case. And the other issue that came up is, so what if the petition for the ex parte order is denied? Can the family member ask for a hearing on that? Or at that point, is there a court order and therefore the case goes to the state's attorneys? We reviewed the legislation and opted for the latter, that basically if it gets denied, the family member can contact the prosecutor and say, look, I'm really desperate. I don't know, maybe I didn't put everything in my petition, but I'm really worried, and see if they can get the prosecutor to refile or request a hearing. But but allowing the family member to litigate when it's basically been transferred to the state's attorney just didn't work. Anyway, that's where we came down on it. But it's not crystal clear in the legislation what happens when it gets denied. But as I read over the legislation, and as others on the committee read over the legislation, it appeared that what the intent was that procedurally, once an order is issued, whether it's an order of denial or an order issuing the temporary order, then the case becomes the state's attorney's.
And this is probably a question for people in the network, but I'm just wondering if the family member, what the experience of the family member is going to the court versus going to the state attorney. If one is more difficult for them if they?
We have a member of the network is on the committee as an advisory member of our committee, Eddie Poff. We asked him that question, but basically no one was aware of any cases where a family member had sought the order, that it is for the most part, it's the prosecutor that's seeking the order, that even including the temporary order. But we felt like at least keeping them in the loop as to when hearings were going to be held, if the legislation allows the state's attorney to dismiss the case for any reason, once they get the case. But that order of dismissal would go to the family member as well. So the family member would know that it had been dismissed.
I can hear it.
I have a specific question and then kind of a flag for us, I think. The specific question is, I know in section 4052 of law 13 BSA, it does say the family division shall have the jurisdiction. And then it also says emergency orders may be issued by a judge of the criminal, civil, or family division. I assume that they'll just look to this rule in the family division if it comes before an emergency in front of a civil or a criminal judge.
I think that's a holdover from relief from abuse proceedings, that language, because once we unified the courts and all the judges became superior judges and the courts were unified, we really don't need that language anymore. Any judge has jurisdiction, any superior court judge would have jurisdiction to issue a temporary order. And in fact, we have one of the rules that we're working on right now is a rule related to relief from abuse proceedings, where we're taking out some language that said something about it was language that still talked about the district court versus the superior court. Right. So it was really pre-unification language.
So that language might,
there was a lot of concern when there was a district court. This goes back to the dark ages, but when there was a district court and a superior court and family proceedings were in superior court, there was a lot of concern when relief from abuse proceedings first started that if the judge that on an emergency basis, so after court hours, if the judge that was sitting in the superior court wasn't available, you wouldn't be able to get a district court judge to issue the temporary restraining order. And so the language in, it's amazing to think that I can go back to all the way to the original relief from abuse for statutes. I know, it's amazing. Talked about that and the rules talked about the need to make it clear that any judge could deal with a temporary order.
Right.
I think with post unification of the courts, that has really become less of an issue.
So let me flag that for Eric. Maybe that's an item for the miscellaneous judiciary bill for this next year.
You're helping with his agenda.
Yeah. So I guess that and I'd also say that this is kind of a situation where I think we need to go back and look at the ERPO law and probably look at what this rule is providing, since it's interpreting what we've,
Yeah, I mean, if you wanted to make it clear that, I think you would have to put it in the legislation. If you wanted to make it clear that the family member has a right to contest a denial of a temporary order, I think that would have that, and it is just not. There's no language to that effect.
I don't think we intended that from having dealt with this, when we passed this, but it's probably worth looking at, because just a flag for you there, and you probably know this, that there's a working group that we established in our miscellaneous bill looking at the issue of providing firearms under ERPO and be for abuse orders. And there may be some that it's November 15th that the report's coming out regarding relinquishment, storage, et cetera. And maybe there'll be more legislation or rulemaking that will be necessary once we see that.
Okay. Any other questions about ERPO? We were surprised not to get any comments.
I know.
This is a whole new rule and literally no comments.
Wow. Interesting.
Anyone on Zoom now, it looks like?
Nope.
No. And actually,
I apologize, I thought you might finish, Judge Jeff, but I was just gonna, in response to your question, Representative Long, about the standby guardianships. If the rules committee would not necessarily be addressing that immediately, we have revised all the forms, the necessary forms of guardianship. Division, probate division for guardianships, to include standby guardianship, so.
So that's a rule that impacts probate, not family. Is that right?
Yes.
Okay, all right. Phew.
Well, thank you for,
All right.
I should have raised that earlier.
All right, and I'll be happy to, or maybe Emily could send you the agenda. You'll see that for our July 11th meeting, and you can see all of the things that we're working on. It's a lot.
we're likely to see you again soon. Is that right?
It's
Your granddaughter.
it's an interesting job.
I bet. Well, thank you for doing it.
Yeah, I enjoy it.
And you for bringing your granddaughter.
Nice to see you.
Oh,
Okay,
yes.
I was gonna do that at Harriet. I want you to, I was gonna do that, but it meant like,
All right.
interrupting me.
So, great. Emily, thank you for anticipating here. I'm going to catch up to you since you are the vet. So you are presenting now on Rule 16.2 and, is that right? And
I
26.
think I'm covering the rest of the agenda.
You are, okay. I am turning it over. Absolutely. You make yourself
I'm sorry.
totally, no,
I
that's
just
great.
realizing I'm running out of juice here.
Yeah, take a picture
I
with you.
apologize.
I know, I will
I know,
miss
this
you.
these back-to-back legislative meetings.
I know, it's been busy. It's busy.
Well, yeah, and this one just requires such a huge amount of driving. I apologize.
Yeah. Well, it's nice to see you. I feel like I always.
Are we gonna try and meet again this fall, Eric, or is this it?
I think
Typically we do, yep.
Yeah, I
that's
think
what
we're gonna
thought.
meet this, yeah. Right,
Right.
great,
We see how many, when the rules come over from the court, that's sort of.
right,
Yeah, no.
Great.
And then we were trying to do this ahead of it. Okay,
great. So we,
great. Thank you. Anyway.
tune in from your
My
car.
committee members,
Right.
off the
So,
Middlebury.
so I am now going to give Emily the floor since it sounds like you are the closer for us.
Well, thank you all. Emily Wetherell, Deputy Clerk of the Supreme Court. I want to just let the committee know that Alan Kais, who's been the chair of the Civil Rules Committee for many, many years, I just want to say on the record that the judiciary just so appreciates the work that he has done on that committee for such a long time. He saw that committee through many, many changes, including the pandemic and the switch to electronic filing and moving to electronic records. And so he has just done an incredible amount of work on that committee, and I really thank him for that.
Proper thank you and celebration. Maybe we should do the same thing.
Yeah, remember the last time that he mentioned that was his last
did
time,
mention
did he?
it.
It was our last one. He did.
Yeah, at the last meeting, I think he did mention that was his last time testifying.
And we said a big thank you, but maybe we need to do more.
Yeah.
Yes.
So I also just wanted to recognize that. Bridget Acey has generously accepted the position as chair of that committee and will do a superb job on that. Unfortunately, she was not able to make the meeting today. She's in a hearing, but you get me instead.
That's great.
So I'm going to cover the remainder of the agenda. Many of these are items that the committee has looked at before, and a lot of them are housekeeping items. So although it looks like a lot of things on the agenda, some of them I think are fairly housekeeping and straightforward. So is that okay to start with 16.2 and 26?
Yeah.
Okay, so these are amendments regarding scheduling orders, and essentially the amendments were made to really conform the rule to best practice and current practice. The amendments on 16.2 on scheduling orders, they allow the
the scheduling order to be made on the stipulation of the parties. In other words, there doesn't have to be a pre-hearing conference. What people were finding is that was just sort of delaying things, that if the parties would stipulate, you don't need to have that, to take the time for having a conference. And then choosing the date of the close of discovery as to the list of things that can be added to the scheduling order. And this sort of conforms to the standard form, and it's kind of the key deadline that is going to be used for caseflow management. And then the amendment also adds any other appropriate matters to the list of the contents of the scheduling order, just to recognize that there might be items that might be included in there that aren't particularly recognized in the other portions. Yeah. There's some reorganization and wording, but that just should not affect the substance of the rule. And then in the Rule 26F, it clarifies that the plan and the schedule for discovery are going to be established in that scheduling order. So really the amendments to 26F are just conforming that rule to what's happening in 16.2. And then it deleted that language that says an order may be altered or amended when justice requires, because that's already included in 16.2 now. And I think when this was reviewed by this committee previously, there weren't any objections to the content of that rule.
Let's see if anyone's changed their mind. So anyone have
I have a
a?
lot of, I have a bigger question or is, does the committee look at the rules in the manner to try to figure out how to become more efficient? I'm just thinking about, I seem to see everything the last couple of years through the eyes of trying to deal with the backlog and trying to move cases along. And is that something that the committee does look at or will look at or should look at, just with an eye towards how can we make things move along a little more expeditiously?
Yeah, that's a great question. I mean, I think things like, for example, allowing those scheduling orders to be done by stipulation instead of having to schedule a status conference in order to enter a discovery order when the parties are stipulating to it. That kind of thing is meant to keep things moving along without taking court time, having to have that scheduling time. I can't say, that would be a question for the committee chair, whether there's been a comprehensive look at all of the rules in order to see whether there are places where maybe efficiencies could be achieved. But certainly every time that there's an amendment that is happening, that is one of the lenses that is being looked at when the amendments are being made. But that could be a suggestion, that this.
An overarching one for each of the committees, so like not just.
Yeah, the suggestion looks, I mean, not necessarily looking at all the rules to see what can be made more efficient. If there are certain rules that it won't make much of a difference, even if you make it a little more efficient. Like, where are there any rules that could be looked at that might be contributing to things being slower? I don't know if that's the best way I'm putting it, but you know what I mean.
What's the impact on the number of cases and the timing of, as well as access, right? People, yeah. It's interesting for our committee to talk about, like, are there 2 or 3 themes that are sort of big that are important?
Yeah, I know in the last, this is my 11th year on this.
Wow.
And in the past, there's been focus on pro se plaintiffs and trying to simplify things. There's been certainly access to justice, and the rules has been definitely focused. And I'm trying to say, please focus also on trying to.
Yeah, and I think that there's a cooperation that happens there between the administration of the courts in general and then the rules committees. So the rules committees are charged with the responsibility for amending the particular procedural rules, but not necessarily in charge with the overall policy of how the courts are going to work or what is the, and the judiciary as a whole. So, in the last few years now, and Terry can speak to this, but the judiciary has a change advisory board and a standard practices committee that are constantly looking at the court procedures, figuring out some of those best practices, and then trying to implement that across the judiciary so that they are standard in all counties, we're not getting, situations where something happens differently in Chittenden County than it does in Franklin County. And in the, we are soliciting input from members of the bar. There's a working group there where we're getting that feedback from the bar. And some of those suggestions absolutely come from within the judiciary, judges who are saying, why are you taking my time to do this particular thing? We could do it faster this way. Or members of the bar who are making those suggestions. And then obviously from the access to justice standpoint, how are we meeting the needs of self-represented litigants, but not taking unnecessary court time to do that. So I think I would say that job isn't just for the rules committees. I would say that job probably rests in the judiciary. And to the extent that those practices change through the change advisory board, then we would need to reach out to the rules committees for them to effectuate that through a rule change. But I think the policy for that and the responsibility for that should rest with the judiciary.
Yeah, no, I think that's like the law actually, you might remember the change advisory board came about in direct response to when e-filing was implemented, to make sure that there was input, opportunities for input from and Emily referenced the court users group, which is court users, including pro se litigants. And they have their, in consultation with the change advisory board that's designed to take input to say, here's where improvements could be made, here's where efficiencies could be achieved, can you do this? And they look at it, and if it's something we can do, or if we have to refer to Tyler, what would be involved to accomplish this? So that came about in direct response to the legislature's request that there be this change advisory board in conjunction with the electronic filing and electronic case management.
Great, thank you. Thank you.
All right. So it looks like no other comments on those.
Great. I will move on to Appellate Rules 30B and E. These were promulgated by the court. This committee previously looked at these amendments, and these amendments are really, there was inadvertently the deadline for the printed case, that it's a unfortunate name, although lawyers have come to know it, and so we have not changed the name of the printed case. But essentially, the printed case is just a compilation of documents from the trial court or administrative agency that are presented to the Supreme Court for easy access to those documents that might be relevant for the appeal. And when that requirement was reinstated in 2024, unfortunately, the deadline for the filing of the printed case was not reinserted into the rule. And so this amendment is just making it clear that that printed case is due to be filed at the same time that the appellant files the principal brief in the case. There was the deadline for the appellee to file a supplemented printed case. And so the amendment is just bringing that into the same part of the rule where the deadline for the filing of the appellant's brief is, printed cases, so that it's clear. It has that heading filing deadlines. It's easy to find. You can see both of the filing deadlines there. That's really the extent of that rule.
Okay, questions, comments?
Looks good.
Okay, I think it'd be good to continue.
Excellent. The next one is a rule change that was done in response to legislation. I imagine some of you remember this whole process, but when the pandemic happened, there was a lot of concern around people having access to a notary to be able to notarize statements. And so one of the emergency rules that were done early on in the pandemic were to allow people to have a statement that they would use, that the items there were true under pains and penalties of perjury, a declaration that they could make. And eventually that was incorporated into the rule. The legislature had there was a piece of legislation there, but it only applied to documents that were electronically filed. So back in 2023, I think this was actually in the miscellaneous bill, Representative Lalonde, you can correct me. That legislation was amended so that it applied to anything that was filed, not just electronically. And so now that provision that was originally included in Rule 11 to allow the use of a declaration in place of a notarized statement. It has been removed. It's been put into Rule 43. So Rule 43 in general talks about affirmation of oath or declaration. And so the Rules Committee felt like that was a better place for that to be instead of in Rule 11. And now the recorder's notes cross-reference the statute, which broadly allows any document that would otherwise require approval or verification of a notary to use a declaration instead. Rule 56 also has been amended to specifically include declarations, and then in the reporter's notes just note that any declaration that's used to support or oppose summary judgment has to be based on personal knowledge.
Were there comments that got?
What I understand is there were no comments that were received on this one.
Just wondered about, I mean, just given about fraud, like if there were any issues that came up, but.
I do not know of any comments that were received on this one.
And do you know how consistent this is with sort of best practices? I mean, from a ease standpoint, it's fantastic, but.
So I don't, that's a great question. I don't know how other states have handled this. I do know that there are, I couldn't say from a survey of other states what percentage of states handle this. I guess the thing I would say is that now we've been doing this for over 4 years without issue. And I think that it certainly does provide, I think that is a barrier for a lot of people to be able to have access to a notary. And so for people to be able to provide that notarized statement in lieu of a notary really is an access to justice issue.
Federal pleadings have allowed declarations for decades, haven't they? For most things.
I think so.
Yeah, because way back when I actually practiced. We always only had declarations. We never had.
And I just haven't done a survey of other states.
Yeah, no, I'm so the Notary Association, hasn't complained or we're putting notaries out of business.
Yeah, it was something that really got raised during the pandemic because people were having issues, obviously, that requires an in-person interaction in order to be able to do it.
I think it's a great rule.
It seems pretty good. I just worry about unintended consequences, just like to check. Yeah, thank you.
You want me to move on?
Yeah.
Okay. With the committee's permission, I'm not going to name all of the environmental court rules that we amended in this comprehensive order. It came to my attention that the environmental court proceedings rules had many references to the now abrogated 2010 Vermont rules for electronic filing, and that those cross-references obviously were very out of date. It created some confusion for people because that reference didn't relate to anything that was in effect. And so essentially these are housekeeping, the majority of these are all housekeeping amendments that remove those and now abrogated references to the 2010 Vermont rules for electronic filing. The one substantive amendment that has been made here is in the Rule 5 for the rules for environmental court proceedings. And I think that's kind of, I don't know if you're on there, but it's on page 5 of that order. And this is in B4A. So that's probably about halfway down on page 5. And this amendment basically requires the service of a notice of appeal on the applicant immediately after an appellant files a notice of appeal and mails a copy to a municipal panel. So this is an appeal from a decision of a municipal panel. Sometimes in those kinds of cases where there's an application to a municipal panel, there could be lots of different parties that have some kind of interest in the proceeding. And sometimes it can take a while to identify who all of those interested parties are that might require notice of the filing of a notice of appeal. But what the committee felt was that it's important that for sure that the applicant for that, permit or whatever they're asking the municipal panel for, that the applicant will for sure be interested in knowing that a notice of appeal has been filed. And so the rule now specifies that when the notice of appeal is filed, the person filing that notice of appeal has to provide notice to the applicant when the notice of appeal is filed. And that allows the applicant to have sufficient notice that a notice of appeal has been filed, and that will not create that delay in giving notice to the applicant. So I would say that's the one substantive provision in this whole package of rule changes, which are otherwise really housekeeping to get rid of the old references to the 2010 Vermont rules for electronic filing.
Great. So anyone have any questions, comments, concerns? Yeah, no, seems good and important that the applicant know.
Excellent. The next one is an order amending, actually, I'm sorry, there's no amendment in this order. This is an order relating to Civil Rule 9.2. Again, this rule has been before this committee several times before. This is a rule that was originally adopted as an emergency amendment back in 2022 to comply with the requirements of the CARES Act. That was the coronavirus, let's see if I can remember it, Coronavirus Aid, Relief, Economic Security Act. And essentially that act required complaints and residential eviction proceedings the rule just says you have to comply with the CARES Act when you file a complaint for a residential eviction. When the rule was first promulgated, the court put a sunset on that provision, thinking that the federal government might repeal the CARES Act after the pandemic had abated. And so there's a sunset of September 30th, 2025. The court directed the Advisory Committee on Civil Rules to review the operation of the rule and recommend whether to terminate, extend, or revise the rule. The committee looked at this several times, and because the federal legislation has not been repealed, the committee decided to go ahead and request that the court make that rule permanent. There's no change to the rule. What this order just does basically is remove that sunset provision and just say we're going to make the rule permanent. If and when the federal government changes that, then there can be a rule amendment made to conform to that. But so that's what the court has done, is make the rule permanent.
Yeah. Is there a typo in the last sentence of the reporter's note where it says, as such, the Vermont Rule 19.2 is made permanent?
There is, yeah.
That's only to show you that I read the report.
Wow.
Thank you.
We might be doing that kind of those. Right?
I'm gonna just make myself a note here. Thank you.
Great. Anyone else? Ian, did you catch anything you wanted to? I'm picking up him.
Oh, no, Martin caught it.
Okay.
For the record, you saw it as well, right?
Oh, yeah, definitely.
Okay, is it all right to move on?
Yes.
The next is a proposed amendment. This is to Civil Rule 65B1. This rule has to do with preliminary injunctions. The way that the rule is currently written is that when you file a complaint, you can include in the complaint a request for a preliminary injunction. That would be a request to prevent the other party from doing something. And what the experience has been is that there has been some delay in having action on preliminary injunctions when they're included in the in a complaint. Sometimes they're not seen by the other side. Sometimes they're not flagged by court staff or the judge that there's actually a motion that's embedded inside the complaint. It's a little bit inconsistent with the Vermont rules for electronic filing, which require every motion to be filed as a separate document so that they are particularly flagged and that staff know to bring those to the attention of a judge. And so the committee thought that it would be best to require any request for a preliminary injunction to be filed as a separate document. So that doesn't mean that you can't request a preliminary injunction at the time that you file your complaint, but you have to do it in a motion as opposed to doing it in the body of the complaint. And that there was a feeling that that would really cut down on the scheduling delays that were happening.
So that might add to court like the workload of the court, but it may reduce compliance issues.
I don't think that it would add to the work of the court because under either procedure, the court would need to rule on that preliminary injunction. I think that in a lot of ways, it will make it easier for court staff because it means that court staff aren't having to scour a complaint and see if there is a request for a preliminary injunction that's embedded somewhere in that. It means that it's brought to the attention of the court staff and then the judge right away. And the other side, obviously, there's a issue there for the other side so that they know there's something there that they need to respond to. So this is out for comment. I understand from Bridget that no comments have been received on that yet.
But we're gonna, yes, we will, so,
Makes a lot of sense.
yeah. Tanya.
I'm sure it's going to come as no surprise that my question is what the conversation was around how it would impact the filer, particularly if they're a pro se filer. This is more work that they have to do. Yes.
Or fee.
I'm not sure if it's more work that they have to do because if they were going to request a preliminary injunction, they would still have to put the put in writing why they're requesting a preliminary injunction. It just means that they have to put it on a separate piece of paper. So self-represented litigants aren't required to electronically file. So in terms of the requirements about electronic filing, unless they choose to do so, they wouldn't be required to comply with those rules. They could be doing it on paper or by email. The requirement for them would just be that they would have their complaint, and then on a separate piece of paper, they would have the motion for the preliminary injunction. And there are forms that anybody, including self-represented litigants, fillable forms that you could use to create that motion.
No, I appreciate that it's maybe not necessarily more work, but it's an additional step and an additional form that they have to fill out that they may not know they have to fill out. So I'm just worried about what the impact may be on adding, you know, anytime there's more forms or an additional step, there's more opportunity for someone to miss it or do it wrong or. So
yeah. Yeah, that's a great, I mean, obviously in any change in the rules, there's something different for people to have to digest and figure out how they're supposed to respond to that. So, you know, hopefully court staff, if this does get promulgated, when it gets promulgated, hopefully then court staff would be alerted to the fact that these would need to be on a separate, in a separate filing so that if there are questions from self-represented litigants, they'd be prepared to answer those.
The change may be more for attorneys because they're the ones filing them all the time, where somebody representing themselves isn't doing it regularly. So
certainly there's no requirement to file for a preliminary injunction.
Of course not. But
Yeah.
So I mean, just with respect to Senator's question, it seems in some respects it's better for pro se if they really want a preliminary injunction to be able to make it very clear to the court that that's one of the relief that they're seeking. I mean, I think it's kind of odd that it could be buried in a complaint and kind of may get lost in the shuffle, particularly because sometimes the pro se complaints are not as clear. And if they have the separate step when they want a preliminary injunction to file the motion, I think that could actually help as well.
I think it might help in the reverse as well, so that it would be clear to them that if there's an attorney on the other side, or even another self-represented litigant, it would be clear to them that the other side is requesting a preliminary injunction in the sense that it's a separate filing. So they know that they can see that there's two things that are being filed with.
So the pro se plaintiff is a defendant.
Exactly.
Yeah, it's kind of clear, it's clear communication for the litigants. And I think that that's generally helpful for the pro se plaintiffs and defendants.
Yeah,
So I do appreciate, sorry, go ahead.
I certainly appreciate the clarity of it. And I just thinking as not an attorney, when I'm sort of like, this is what happened, this is what I want, I don't think to separate those things. And so as you know, as long as it is well communicated and it's sort of there's somewhere where it's very clear what the steps are, I think it's okay. And I do absolutely appreciate that it's more clear. I think Senator or Representative Lalonde, I'm trying to give you maybe a promotion, I don't know.
God knows.
You know, I think you're wearing your lawyer hat. It's like, yes, this just makes more sense, but sort of wearing my I'm not an attorney hat, I'm like, that's not how I think. I don't think to break those things into two separate pieces. So I like I said, I appreciate the clarity. I just want to be thoughtful about, you know, what the impact is for non-lawyers and how we make sure we communicate clearly to them that there are in fact two steps and they need to separate those pieces.
Agreed. Yeah, no, definitely agree.
Good. Any other comments or questions? I don't know, Emily, if you were totally done with that one or if you wanted to.
That's great. Unless there are other questions, I'll definitely report that back to the committee. Thank you, Senator. The last one, I think it's maybe the last one, are amendments to two appellate rules, Appellate Rule 10 and 31. And these are really technical housekeeping amendments that are updating some cross-references. So as to Appellate Rule 10, there's just a change in the cross-reference there. There was a amendment to Appellate Rule 24, and that changed the provision from D to C where that this cross-reference is referring to. And so that cross-reference just needed to be updated. And then related to Appellate Rule 31, there's a cross-reference in Appellate Rule 31 to Rule 10C2, which no longer exists. That was a rule that referred to video recorded proceedings, and all of the proceedings in the Superior Courts for some time now have just been audio recorded. And so that rule was removed back in 2021, and there's a cross-reference there that just was not updated. So these are really technical housekeeping amendments.
Questions? No. Yeah, great. Are you?
I'm good.
You're good, okay. So I think we're,
5 minutes.
wow.
Nicely done.
Thanks for, I've helped with, gosh, I think I've been on this committee 11 years. That's like, oh my God. It's like my second, I guess my third year on it, but yeah. Thank you. So any other agenda items that anyone has that they want to make sure we're putting on the agenda for the fall, which we will have a meeting sometime this fall.
Yes, you were kind of raising this topic earlier as well, that usually you definitely meet once more. And then and sometimes you meet twice more. Sometimes it might be in October and then maybe a December one. But that will sort of depend somewhat on how active the committees are in the court for sending out rules this fall. If there's not that many before January, maybe we'd hold off, but on the other hand, it can be difficult to meet during the session. So sometimes it's helpful to clear the docket in December so that everything's kind of taken care of before. So we'll just see how many are out.
Yeah, and to Senator Brock's point, like we should do what we can to help make sure we are being part of the solution of moving things along and not contributing to the backlog, and also getting a good handle on what's happening and out there. And to Martin's point, if we can also help frame some key questions that might, or not questions, but just hopes that we have for committees to be remembering impact on the core backlog. Or making sure we're educating the public as we're making changes, that we are communicating that and trying to be part of the solution. But thank you, my goodness, had a super busy.
I was just gonna say, we could certainly, and as everyone said, I don't know if it was like a directive, but it makes perfect sense and they are seeking efficiencies typically. But we can also, and I can speak with Judge Zone, because he has regular judge meetings, to say if there are any rules that do, cause delays in their view, in terms of the ability to process the cases. And I wanted to also make mention that Emily very nicely thought to have a reception to, for all the Rules Committee members, now that we mostly meet remotely, so there isn't the opportunity. So that's been scheduled for in August, and I don't, March, September, okay. And hopefully I can advertise, Attorney Kai's would be a chance to thank him.
Great, that's awesome. Senator Brock.
Just to add to some of the comments earlier regarding time and timing, there were a number of items that were raised today that appeared to have been on an agenda somewhere for literally years. That we heard about today. And I wonder, and the look back that is to be done between now and the next meeting, if we might just take a look at things that we've dealt with recently and are proposed to deal with in our next meeting, how long they've been at various stages of the agenda. I'm just a little concerned that if what we are doing is important, it ought to be done in a timely fashion. If it's not important, we ought to stop doing it. And maybe this will point to that.
Good point. I mean, we do want to use everybody's time wisely and not make busy work for anyone.
Personally, I feel this is very important and very helpful because it gives the public's perspective on these rules. And part of the delay, Senator Brock, if you will, the timeline itself, because of the comment period that's involved and the desire to want to make sure that people have the opportunity to provide input, that I guess builds in some delay. We also otherwise have the emergency rule option if something needs to be, attended to very quickly.
Today, though, we heard about an issue that first arose in 2019, and we are dealing with it coming to us today. It's hard to imagine that something has to move that slowly. We heard of other things that related to a rule change or change in process that occurred in 2010, and we're dealing with it today. So I'm just wondering, is there a methodology that we should use to at least alert ourselves to how long something is taking? Because some of these things may be purely procedural and not necessarily life-changing, but some of the things that we've seen come up are. And I'd like to know, do we have a process to identify which is which and to expedite those things that need to be moved forward faster?
And I very much appreciate your point. It's so well taken. And I agree that 2019, and I don't know, in fact, I think the Evidence Rules Committee does meet less regularly, and I don't know what the reasons were for that very long period of time. I'm hopeful that this will show that that is indeed an aberration. And in terms of 2010, that was just simply a matter of the 2010 rules for electronic filing were a body, and the fact that there was a reference to those in some of the rules, it didn't update to the 2020. That didn't reflect upon something not being changed or something, waiting 10 years to happen. But your point is very well taken, and I appreciate this chance at the next meeting so we can address it specifically and detail.
And maybe look at, just like the courts have done, like what's our ideal metric of how long should it take? And it's probably different for different types of rules, but it might just be a good conversation to sort of think about, like, in what's the quickest we can do without cutting off public input and the other important elements.
Well, it's recognized your committee's constraints during the legislative session to meet, that's the.
But again, if we're getting in the way of that, then I think if we don't have a backlog going into session, we can have short meetings during the other committees meet during that time period, and we should look at that too. Because should we be part of the problem?
Well, I think it's going to be a very good exercise.
Yeah, for all of us. So Senator Tanya, go ahead.
Yeah, absolutely. I'm wondering if it makes sense because the point is very well taken. And I know, Senator Brock and I also were on the government accountability committee a couple of years ago. And we sort of looked at like how other states manage the sort of rulemaking from that standpoint. And what I remember what we discovered then is there was a whole lot of rulemaking that just hadn't happened. So I wonder if it also makes sense maybe to reach out to NCSL or CSG to see how other states keep track of this and maybe not recreate the wheel, but learn from what other states might be doing.
I love that idea. Okay, great. Thank you. So, yeah, I can certainly do that. So any other business announcements?
I could do that part, just chipping in response as far as an NCSL request, see if there's any information out there about how other states look at this.
Awesome. Good. So I think we can adjourn, right? Because there was a lot to. Yeah. All right. So I need a motion to adjourn or not?
Nope.
Nope. Okay.